Good morning, everyone, and welcome to the District of Columbia Court of Appeals. We have two cases on this morning's calendar. The first one is number 25 SP 378, in re prosecution of Malik Handy. Counsel, whenever you're ready.
Thank you. Good morning, and may it please the court. John Nortorena on behalf of Mr. Malik Handy. I'd like to reserve 3 minutes in rebuttal for Mr. Handy. The council exceeded its Home Rule Act authority in designating the OAG for the prosecutor for the transportation offenses for 3 reasons. First, unlike any 23-101 case that this court has ever addressed, the council did not write on a blank slate in creating this offense. It amended a statute that already existed in Title 22 and descended from an entire congressional enactment that included sister offenses that address the carrying and possession of dangerous weapons. Second, the UT offense is more like CPWL than it is unlawful, unregistered firearm and unlawful ammunition, in that UT is directed at the manner of carrying a dangerous weapon instead of the ministerial requirements that the firearm be registered. And third, the Chapter 45 offenses have always been prosecuted by—
Can I just slow you down on the second one?
Sure.
CPWL is like the UF statute in a way, in the sense that it requires having a piece of paper before you can do a thing. So I'm not sure how you line up CPWL with the contrast you were identifying between UF and UT, to use all the acronyms, for which I apologize.
Well, this court held in Plummer that the CPWL statute, the felony provision there, was directed at conduct and not directed at the license requirement. And so that's the difference between that. So the Chapter 45 offenses—
Just again,
sure.
Do you think it somehow is more directed at conduct than possession of an unregistered firearm is? Because I mean, they both seem very structurally similar. There's a piece of paper you have to have before you do a thing. In one, it's a license before you carry, and the other, it's registration before you possess. So they seem very similar in their structure. So if UF and CPWL are allocated differently as far as prosecutorial authority, I'm not quite sure I follow how that would be a function of the kind of structure or nature of those offenses at that level of analysis. So am I missing a distinction?
No, I see this. I see the similarity that you're drawing, Judge McLeese, between the unregistered firearm requiring a piece of paper and the CPWL also requiring a license. But when we're talking—
and just that was half of it, and the other half is, and then each of you, if you don't have the piece of paper, then you can't do a thing. You can't either carry it for CPWL or you can't possess it for UF. Now, I mean, carrying feels more verb-like than possessing, so maybe there's some distinction going on there, but I'm just not quite sure yet I see the distinction.
The distinction that I would draw is that it's conduct that you are going after with CPWL in the criminal law, whereas in the UFUA, it's simply going and registering a firearm as opposed to carrying a dangerous weapon out on the street that presents a danger to other people.
Is that because you think conduct, that carrying is more conduct-like than possessing, or for some other reason?
I do believe that there's a distinction between the Title VII offenses that ask you to register a firearm versus the carrying of a dangerous weapon in a densely populated area.
Yeah, I'm not getting it, I guess, because it's all a question of how you word it. You can say that the CPWL statute requires you have a license, and the UF statute requires that you have a registration. So I mean, they both have two halves, one of which is to have a piece of paper, the others which don't do a thing. And so the distinction you're drawing, I don't mean to be obtuse, I guess, but I'm not, unless you're drawing a distinction between possessing being less of an active, less verb-like than carrying. I'm not sure I see a distinction yet. So
yeah, well, we're talking about a transportation statute where we are talking about carrying. We're talking about the movement of the weapon as opposed to going to the police department, showing the firearm and filing a piece of paper and getting a registration certificate back. And so that's a distinction I would draw. And I would say that the CPWL has always been tethered to this exception, and OAG has never prosecuted DWA offenses and they can't show any sort of enforcement history. So going to McIntosh, I just wanted the court to, there's two.
But sorry, just to stay on CPWL for a minute.
Sure.
I mean, maybe the argument is that CPWL is more like UF and UA and has been wrongly prosecuted for some period of time. It seems like, you know, possibly the government's argument opens that door. But then how does that help you? If possibly CPWL has been wrongly prosecuted, then I'm not sure how that helps you.
Well, I don't think it's been wrongly prosecuted, so I'll start with that premise. And this leads into my next argument, which is that there's two systems of regulation in the District of Columbia. There's the first, the Dangerous Weapon Act of 1932, which is a congressional enactment. And then there's the Title VII FCRA-like act, which was meant to supplement, which is what the court said, this court said in McIntosh, that there are these dual systems. There are two trains on two separate tracks. And in creating that UT offense, the council specifically said we are designating, we are amending this Title 22 statute, and we are designating OAG as a prosecutor. That violated the Home Rule Act because you can't designate the prosecutor for without running headlong into that provision relating to the duties of the U.S. attorney.
I mean, that seems circular, I guess. If you assume that the provision that designates OAG as the prosecutor here didn't exist, but that the legislative history indicated that that's what the council wanted, and if the factors at issue in Settles pointed in favor of that as the right answer to the question, which I know you don't agree with, then the provision saying, by the way, the right prosecutor is OAG wouldn't violate the Home Rule Act. It would just be an accurate description of what the Settles factors would tell you is the right prosecutor. So it seems like it's circular. The provision violates the Home Rule Act only if you're right on the merits. If you're wrong on the merits, then the provision doesn't violate the Home Rule Act and instead correctly says who the prosecutor is. Or is that, do you agree with that?
Yeah, I do agree with that, and I'm right on the merits, and I think the settled factors weigh in favor of the USAO being the prosecutor in this case. It's different from Perot, the Perot case in this court, where the council wrote on a blank slate. And they inserted the provision of voyeurism in the Title 22 statute and designated OAG as the prosecutor. And this court held that, you know, the voyeurism statute is not a legislative, it's a legislative act. It's not a police pronouncement from the police department. This is similar in that regard. If you look at footnote 14 in Perot, it specifically makes that distinction between what is a police regulation and what is a legislative enactment. The history of this.
Can I
Sure.
interrupt just before you get too far away from this? You said that you referred to CPWL as always being very closely tethered to UT, and you know, but the relationship is interesting or unusual, I guess, in that for at least in more recent years, it's been recognized over the years that it is as a defense. So is the fact of this, the statute being a defense, you know, in the way that it's tethered to CPWL, a neutral fact regarding whether it's a penalty or a regulation, or does it cut one way or the other?
Well, I believe that like you said, it did exist as a defense. And then when they came in and criminalized it, I think the fact that they criminalized it in that statute, that does make it more of a law than a regulation, like a penal type law more than a regulation.
But okay, but the history then is not in your favor.
History is in my favor because it traces back to this particular statute that the council amended, traces back to the 1930, specifically Section 5 of the 1932 Dangerous Weapon Act.
And it's the idea that it's like some sort of preemption analysis that you know, 18 USC 926A and the Dangerous Weapons Act of 1932 kind of occupy the field. And so there couldn't have been an analogous police regulation? I mean, there was eventually one in 1968, right? But like back in 1933, say that there couldn't have been an analogous police regulation at that point because the congressional actions occupied the field. Is that?
No, there could have been a police regulation as long as it didn't conflict. There could have been a police regulation under the DC Code Power now 1-303.43. So they
Then
certainly,
doesn't that give away your, if there could have been, then why does that help you?
well, because the Dangerous Weapon Act of 1932 came first, and they basically said, this is the way that you transport a firearm. It has to be in a secure wrapper and it has to be unloaded.
Right. And so they did that and said, you know, if it's a defense, if you do these things, and you're saying, if I understand correctly, it would have been just fine for the local government at that point to say, as a complement to that, we're going to criminalize the failure to keep the gun secured in the manner that allows this defense under federal law. You're saying that would have been totally fine, and that seems to, if I'm understanding you correctly.
Well, I first, I don't think there was a statute or any type of regulation between 1932 and 1968. The first time we see any sort of provision that deals with transportation is in the 1968 Police Regulation Act. And as this court said in McIntosh and Maryland Rifle, it is allowed, they're allowed to supplement the DWA Act. Does that mean that OAG now all of a sudden has prosecutorial authority over the Title 22 crimes? No, it does not. It means simply that the council can fill in legislative gaps where they see fit.
Right, but just to put it concretely, imagine that instead of placing this in Title 22, which is an important one of the factors that you're relying on, if the legislature here had put it in Title 7 and had said, you know, consistently with what it said in its active provision, OAG is going to prosecute it. We think of it as a police or municipal ordinance or regulation, and it said, let's say, in its legislative history, and the penalties were the same here, which I know is a topic we haven't shifted to, and had said there isn't really any prior history of prosecution of this offense as such, proper prosecution of this offense as such. There, you know, there were defenses floating around, and at time people incorrectly thought it was a prosecutorial offense, but it wasn't. So we don't think of that as a history of prosecution. Do you think the settles factors would be different in that hypothetical? Some of them would be less favorable to you than you argue the current case presents. Do you still think that that's something that would be beyond the power of the council if it had done all of that? Or do you think that, I'm sorry?
It goes back to your point, Judge. It goes back to your point about the settles factors, and if the settles factors weigh in favor of USAO being the prosecutor, or the contrary, that OAG is the prosecutor.
Understood. I'm just trying to change some of those
Right,
factors.
I understand
and
that.
See what you think the outcome would be if those
I think
factors were different.
I mean, what you just laid out is what the facts were in Hall, right? Where you've got this police regulation that creates the UF and UA offenses, and then it directly descends all the way up to through the FCRA, and then codified in Title 7. And the court in Hall held that long history of regulation that the district cites back to 1800, plus the fact that it was codified.
That's not quite in the hypothetical I gave, which is this case varied a little bit. There wouldn't have been a long history of DC prosecution of this particular kind of conduct. There would be a history of general regulation of firearms. So it wouldn't quite be the same necessarily. But let me just very concretely, do you think on the question of the factor of kind of history of prior prosecution, do you think that a period of a federal prosecution that was incorrect in character because it actually wasn't an offense is like a nullity we shouldn't take into account as part of the prosecution that's really wrong, misprosecution? Or do you think we should take it into account because whatever people thought about whether it was or wasn't an offense, they at least were thinking it is the federal entities that should be making that call? Which do you think it is?
I think that that does weigh in favor. I don't know if it strongly weighs in favor, but I do think that it weighs in favor. And going back to your previous question about the settles factors in that hypothetical, I think the legislative history there would be in my favor. Because I don't think what the court in Hall said was you're able to trace this back to the direct descendants of the 1968 police regulations promulgated under 303.43, upheld by McIntosh, and then carried forward to the FCRA in exact same form, exact same language, and then carried forward to Title VII with the exact same form and exact same language.
Yes, but I mean, in Settles, we did say that the direct descendant line of thinking in Hall was not an absolute prerequisite and didn't preclude the idea that that factor might well still favor OAG as the right prosecutor. So I'm not sure that direct descendant is a prerequisite in the way your comments are suggesting.
Well, I think that the district is relying on that. They're relying on saying that because this descended from, we regulated this in 1968, that we now also have a prosecutorial authority over the Title 22 offense. And that is just not the case, because in 1968, that language was never carried forward as part of the FCRA, and it was never carried forward into Title VII. And really, the only distinction between that, what was in the 68 regulation, and the DWA is just that it was carried openly. That the firearm had to be carried openly in the secured package, which has never been the case here. And what the council did when they finally, I'm out of time, Your Honor. May I just finish?
Please.
The council did when they did finally have to confront this issue after Heller. They adopted the language from 926A, and going back to your point, Judge Easterly, 927 says it's not meant to preempt state law regulation, but that does not bear on whether or not the prosecutor of the offense is OAG or USAO. I think it is USAO, given the codification provision, the conduct that it's directed at, and the history of enforcement and the legislative history and statutory context.
Okay, thank you. We will give you some time for rebuttal. Mr. Schifferle.
Good morning, and may it please the court, Carl Schifferle for the District of Columbia. Also at council table is Ms. Park on behalf of the United States. We intend to split our time with the court's permission.
Sure.
Okay. Let me start, I think, sort of where we left off, which is what I understood counsel on the other side to recognize, is that if the council had simply directed that this particular unlawful transportation provision be codified in Title VII, then that we wouldn't even be here, that he would acknowledge that the council has the authority to do that. And if it had done that, it would satisfy the legal test, the settles factors for properly.
That seems like that's just one settles factor, right? Why would that one be dispositive?
No, that's correct.
Understanding what you're saying, like you seem to take his assertion as just sort of a concession of the whole ball game, that if this had been in Title VII, that's the end of the analysis. But I don't know that that is the end of the analysis under settles. It's just one factor.
I acknowledge that, and I certainly can get to the other factors, but I think it indicates that the argument on the other side is just very formalistic. It's not based on the substance.
And on the placement in Title 22 versus Title 27, how did that come to be, right? In this case, why is the UT statute in Title 22?
It would appear because the act that created the current unlawful transportation provision was an amendment to the 1932.
There's nothing in the statute itself that says we're amending Title 22, right? Is there?
There may be, but there's certainly no directive as to where it's to be codified.
My understanding is the way things end up in titles in the DC code is that either the council says specifically, we're amending this provision that's already in a particular title, so the codifiers know where to put the amendment, or the council's OGC says, oh, well, we think this is where the amendment goes. And if it's the former, then sort of it seems duplicative of considering legislative history. And if it's the latter, I'm not sure why we would give any particular weight to staff from the council, from, OGC. I don't know. I know it's a factor in settles, but I'm been kind of scratching my head as to why we really care about where it is in the DC code.
Right. And it can, and yes, I do agree that the codification isn't a particularly strong factor for the reasons Judge Easterly, you identified. It may reflect sort of the overall legislative intent, whether this be a police regulation more akin to a penal statute. But here we have the clear indication.
We know what the legislative intent was.
Exactly.
They said so, right?
Exactly. And so
but then again, like how much weight do we give that? Because we said in Crawley, it's not dispositive, but we said in Settles, you can still consider it. So what do we do with that?
I mean, it is entitled to some weight overall in the entirety of the Settles factors. I don't think it's the most determinative. I would certainly start with the first Settles factor, which is whether this is a local regulation. Or
Let's go there then. If you think that that's the most helpful, why do you think that this is a local regulation? I guess there are a couple things that make this seem very different than, say, Settles, where we're talking about, dumping regulations. We're talking about transportation, which, sometimes requires, roads going interstate, and you might be on federal highways in the district. And so transportation seems to kind of open this up beyond the local. And we're also talking about guns, which, are federally regulated. There are federal statutes related to guns. And then beyond that, there are Second Amendment concerns. It just seems like this is much more than a local concern in some respects. And I'm trying to figure out how to, obviously the district has a particular concern in guns and who has access to them and how they're transported. But there seem to be these broader concerns as well.
Right. I think I would start with recognizing the distinction between local regulation as opposed to absolute prohibition. And so if we think in terms of whether this is an absolute prohibition, clearly it is not. It does allow the transport of a firearm subject to certain conditions, the who, the where, the how of the firearm is to be transported.
We said in Settles, we acknowledged in Settles that there's a certain circularity to that. I mean, everything absolutely prohibits whatever anything that prohibits anything absolutely prohibits what it prohibits and doesn't prohibit the rest, and nothing prohibits everything. So you're right that it permits transportation. But I mean, like a murder statute prohibits killing humans. It doesn't, it's not an absolute prohibition on killing. It's it's a limited prohibition on killing humans. And so there's a certain there's a generality problem of nothing is absolutely absolute. Everything is, in its context, absolute as far as it goes and not absolute as far as it doesn't. So can you help? I just struggle with that aspect of things because I can certainly see it one way, which is it's not an absolute prohibition on transporting guns. It's a manner. It's really a time, place, and manner. It's like a time, place, and manner type restriction. So it doesn't feel as categorical a prohibition. So I get that line of thought, but then everything seems like it is has its prohibitions only to a certain degree with respect to manner or time or place. So I just don't know how much to make of that or some sense of. I mean, do you have any idea of getting out of that circularity that I struggle with?
Yeah, I mean, I think, as Your Honor recognized in the Settles opinion, that it doesn't make sense to think of it in terms of course, a statute absolutely prohibits what it makes illegal. And so we shouldn't think of it at that level of generality. we can still think of it as a factor, and this is exactly what the settles court did. It recognized that, in that case, the solid waste disposal statute, it did permit the disposal of solid waste.
Although that was easier because it literally said there are some places in DC you can do this and some places in DC you can't, which is not true of this transportation. It's not like locally variant about the legality of your conduct depending where you are in DC. Let me ask you, maybe you can help me with this. Do you think CPWL is a local regulation, or do you think on this factor first? I'm not asking you yet the overall answer to the question of who the right prosecutor is for CPWL misdemeanor, but I'm just asking you on the first feature. Do you think CPWL is kind of local in its character or absolute prohibition in its character?
I think it is less of an absolute prohibition and more of something that is akin to a local regulation. Again, because what the test, we're offering here is looking at whether it is something like an absolute prohibition, as in the case of voyeurism or solicitation of prostitution. These are general criminal offenses. And when you are talking about something like unlawful transportation or disposal of solid waste, those seem, on the different end of the spectrum.
That makes me wonder or ask if are there gray areas? You seem to be assuming that there are on this question. I understand on all these factors, we're sort of like, how much do you weigh it? But on the question whether something is particularly applicable to inhabitants of a particular place or this absolute prohibition, is it just like, oh, it's sort of more of one as opposed to almost as a matter of law in one category?
Yeah, I mean, I can't deny that, maybe there's some gray area for the reason that Judge McLeese mentioned, that sort of there is a certain level of generality issue. But I think if you sort of step back a little bit in terms of how this court's case law plays out, again, with the unregistered firearm, unlawful ammunition statutes in Hall, the solid waste disposal statute in Settles, that's much more akin to the unlawful transportation statute here than general crimes, absolute prohibitions, voyeurism, solicitation of prostitution.
I tease out one thing. I mean, my understanding, but maybe this is mistaken, is that this kind of dichotomy between local regulation, between general prohibition, both incorporated this idea of, are you regulating versus prohibiting something, but also had this sense of, is this of local concern versus more, general concern? Maybe that's wrong. And that's, that second vein or idea strand was why I was asking about, well, does it matter that we're talking about transportation, on roads that take you places, maybe from outside the district, in the district, and then outside again? Does it matter that this implicates perhaps, Second Amendment concerns and federal statutes that regulate transportation of guns, right? Which seems different, very different than anything that we were talking about in Hall or in Settles, right? Because Hall is just about like, when you are here, this is, you have to have your registration, right? Versus for the unlawful transport, you might be in transit. So.
True, but you would be still here in the district. The regulation only governs the district's boundaries.
Sure.
Transportation is something that I think is local in nature. I mean, things like speed limits and all kinds of traffic regulations and signs. Those are, I would say, distinctly local in character. I would also say that the decision to regulate transportation of firearms depends very differently on the locale. The district, high-density urban location is very different from somewhere like Wyoming. And in fact, I think the federal statute, the 1986 statute governing transportation of firearms, recognizes this by specifically saying, here's a safe harbor, but we are specifically not preempting the field. We are allowing states, including the District of Columbia, to regulate in this field. And that's exactly what the district has done here by crafting an unlawful transportation statute that again specifies the where, when, and how, particular to the district. But I wouldn't think of it as two different factors. I would want to keep it as one factor. So absolute.
Sorry to just cut, I think I get your sense, but just to your point of the federal statute leaves open this space for regulation. Would it be important for us to look to see who's doing that regulation in the space that's left open, whether it is state authorities versus municipal authorities?
No, I would say not, particularly now we're in the era of home rule. The council has, the legislative
The
authority.
council wears two hats, which is kind of part of the problem here, right? Because the council can act, we seem to have recognized it in its police regulatory authority or its, penal code authority. And we're just trying to figure out which they were trying to do. We do know they said prosecute this, let the OAG prosecute this, but their views are not dispositive, so it just seems like maybe it would be relevant to see, whether in other jurisdictions, these, the transportation regulations are being, it's being regulated by the state versus, does Boise get to decide, or is it the whole state of Idaho? I don't know.
Yeah, I mean, I would resist looking at the locality level just because the district is a state for just like, for purposes of that statute, just like any other state to the extent
That
the
would
state.
seem to point in the other direction, no? Or do you think states can impose police regulations? I thought
Sure.
police regulations were more in the nature of municipal regulations, but maybe I'm wrong about that.
I mean, I don't know, maybe I'm getting tied up in the fact that the district is like a locality, but it's also like a state. It is a unique creature. I think it's more helpful to think of in terms of the second settles factor, which I think does more relate to, Judge Easterly, your question in terms of whether this is like a police regulation or whether it's a penal statute. And when you have a long history of regulation by the district in this area, that is certainly a strong indicator going back more than a century. You can look at the 1906 authorization from Congress for the district to, adopt all usual and reasonable regulations to regulate firearms. That authority has remained intact since then, despite the 1932 Act that did not preempt the field, that did not cause the district to lose that authority, has continued to exercise that authority. There's
Well, the exercise though, right? I mean, does it, again, it's like a question of how specific, how general do we go? Certainly there's no evidence that the district exercised its authority to regulate the transportation of firearms until 1968, right? I mean,
yeah.
even in 1968, it's still this permissive, you can do it this way. It's not, we're going to prosecute you if you don't do it the right way.
I do recognize that. I do want to avoid relying on a direct descendant, going back, beyond.
And I get it. And I know that Settles said that you don't categorically need a direct descendant, but Settles also didn't say the lack of a categorical descendant is irrelevant, right? I mean, it's again, we're in this kind of gray area of, it matters to some degree. How much? We're not sure.
Right. There are a variety of factors at play. I think ultimately, basically, they all favor the district. But I don't think the factor wasn't even.
You don't think the placement in the code factor features the district, do you? I thought that one was on.
Right. No, I recognize.
Was indisputably against you.
Strictly speaking, right. That does not favor us. But my argument is that is sort of a proxy or some sign or indication of what the legislative intent is. But here where we have the clear indication.
Maybe, but if it was just the staffers of the council, then is it really a proxy of legislative intent? Like that it happens after the statute is enacted? That doesn't seem like how we do legislative intent.
Yeah, maybe proxy was too strong a word. I'm just trying to consistent with settles, recognize that it may be some evidence or some indication of legislative intent.
Well, and in this particular case, I think, I mean, the way it varies, and I think the United States made the point that it may be that it was only a codifier who figured out in the original congressional act what title of the U.S. code to put in, or so maybe that's true, but I think the actual enacted statute as passed in this case that created this offense specifically says we're amending a particular code provisions. So the legislature here, in what it enacted, contemplated that it was placing, by choosing to enact what it did as an amendment to things that were in, not just by referring to the original act and not knowing where it was. It expressly says we are, amending paren and has the code site. So I think the enacted language reflects that the legislature consciously placed this offense in Title 22. Now, what weight to give that? I mean, I take your point that why is that relevant except on the issue of legislative intent? And here, the legislature, so maybe they're cross-cutting considerations to a degree, but here the legislature enacted a provision telling us what its intent was. So I get that point. But I do think here there's a pretty strong indication. I mean, it wasn't, I think the council is chargeable with the knowledge that the language it enacted placed this in Title 22, which is a settles factor that we treat as not, we didn't describe it in settles, maybe we should have, but we didn't describe it as it's a factor that's really a subpart of the sixth settles factor instead of its own factor. We didn't do it that way. Maybe we should have, but that's not how we teed it up in settles, at least.
Right, that's fair, but I think it is helpful to think when there are factors, not uniformly on one side or the other, how do you balance that? How do you weigh that? I certainly think that when there's clear indication of legislative intent, that would outweigh the codification. I recall that
factor, because you did say, I guess, responding to your saying that all the factors favored you, and I think we're now acknowledge at least one may not, but multiple prosecutors. I know that both you and the United States made the point that UT does not have its own internal repeat offender provision. But Mr. Mortorano in his reply brief says, well, that's true, but the general repeat offender statute would be applicable to UT. And therefore, there would be UT prosecutions where the defendant would be subject to up to 3 years of incarceration, which, depending on what view, I guess that so my question is, A, do you agree that's right, that as a legal matter, it is possible that there could be a repeat offender prosecution for UT where the defendant would face up to 3 years in jail? Do you think that's accurate?
my understanding is yes.
And what do you think that, do you think such a prosecution could be conducted by OAG, or do you think it could only be conducted by the U.S. Attorney's Office?
I believe that could be conducted by OAG. That would be our position. The reason is that these general recidivist statutes generally don't have implications for questions like this. So, for example, with respect to whether an indictment is required, because it's a felony more than a year sentence, we don't look to a recidivist statute. That was
Relying on the Smith case.
Smith case,
Yeah.
right?
I must say, Smith is an old case, and I am not entirely sure it would come out the same way nowadays, but I take that line of thought for sure.
And if I could, I mean, it relies on.
Didn't Hall, I mean, you think it matters whether the provision is internal to the statute at issue as opposed to external and in some other provision of the DC code? Is that the distinction you're drawing? Because in Hall, we did seem to think that there was these, recidivism provisions like that, which might not create it as a felony, still gave rise to multiple prosecutors. Though I think that was conceded in Hall, so maybe that's another part of your answer. But
Right. So ultimately, the multiple prosecutors didn't matter in Hall. It was still a DC prosecuted offense. But in that case, the enhanced penalty for recidivism was in the particular provision.
And why does that matter?
It was not a sort
Why
of
does that
general. And that is an important distinction. There was both the Smith case, but it also relied upon the Lawrence case, an earlier decision, which involved whether the former Court of General Sessions had.
Before you move on to the second, just you don't think the Smith case implies that it would have come out differently if the provision at issue there was internal to the statute in question rather than a general enhancement provision, or do you? You think whether something is a felony would depend, whether a recidivism statute creates a felony depends on whether it is an offense-specific recidivism statute or a general recidivism statute? Because
Yeah,
that would,
that's my understanding from the case law. I would also note, I mentioned Lawrence.
I interrupted you before you went to your second point in Lawrence, so I feel free to get back to the point you were making about Lawrence, because you definitely didn't get to complete that thought, so.
Okay, thank you. So yes, the Court of General Sessions was a court of limited jurisdiction. It only had authority to hear prosecutions involving a sentence up to a year. And in that case, the court once again said even if a general recidivist statute would increase the sentence beyond a 1 year, Court of General Sessions still had jurisdiction. There was the Brown case, Brown versus United States in 1996 from this court with respect to the jury trial right. Again, the general recidivist statute didn't affect the demarcation, in that case, 6 months, generally speaking, for the right to a jury trial. So there's plenty of authority.
But what's the theory underlying it, or is it just, that's what the cases say?
I think because the general recidivist statute does not change the nature of the offense itself in terms of how it is classified, felony versus misdemeanor, or just looking at the punishment that statute imposes. We don't.
Yeah, I mean, my general fear about those cases, which is that they're before the Supreme Court decision in Apprendi, and they, I think, reflect sort of a disaggregation of penalty consequences, general in character, I guess, from how you assess the penalties that relate to a particular crime. So I think it's an interesting topic how that would all fit together, but that certainly hasn't been teed up here.
Yeah, and I don't think I need to rely on sort of the continuing soundness of those cases for the particular holdings in those cases, but just to recognize that when we're interpreting a district statute here and looking to whether this counts as a police or municipal ordinance or regulation, and where the penalty is just one factor, none of this is necessarily dispositive. Even in Hall, where there was the repeat offender provision that would concededly bring that repeat charge before the U.S. Attorney's Office as the proper prosecutor, nevertheless, there, OAG was the proper prosecutor.
I foreshadowed this question, so you've had at least some time to maybe think about it, leaving aside what you did in preparation for argument. But what is the district's position about whether misdemeanor CPWO offenses should be prosecuted, if correctly understood, should be prosecuted by the district or by the U.S. Attorney's Office? And if your answer is different from your answer about UT, can you explain why you think the settles factors work differently between the two?
Sure. We're not here asserting some right to prosecute CPWL. That's not the district's position. If there is a need to distinguish between the two to explain why CPWL is prosecuted by the U.S. Attorney's Office and unlawful transportation is prosecuted by the district, one settles factor, of course, is the history of regulation and prosecution. We don't deny that since 1932, it's the U.S. Attorney's Office that has been prosecuting those charges, and so I think the history is, potentially a quite important factor if that were the analysis that the court went to go down.
So that's one variable for sure, and I get that as a possible distinction. Do you think that CPWO misdemeanor and UT are different with respect to any of the other settles factors, or do you think? I think you would think, because CPWL does have its own internal enhancement provision and felony provisions, so it's more clearly a multiple prosecution problem. So I get that too. But
Yeah,
do you think they're different conceptually on the first of the settles factors? Do you think CPWL is more or less local or absolutely prohibitory, or any of the other phrases we use as we struggle with the first factor?
Yeah, I mean, if I have to answer, I would say that CPWL does strike me as more regulatory than absolute prohibition. I don't think quite to the extent that the unlawful transportation statute is. I think, it spells out quite a number of conditions and circumstances in which the transport of a firearm is lawful or unlawful. I mean, I could go through it, but it's quite a few steps that you have to go through. It's not quite as simple as the CPWL statute.
I just have one more question.
Yeah.
Others may have others, but we didn't in settles say anything explicit about which of the factors, if any, are more significant or less significant in general, or even in that case, we didn't sort of say, well, in this particular case, we find one more important than the other. Do you think you can extract from our cases some thoughts about that, or do you have your a position about, as among the factors, whether in this case or in general, there are some that seem to be more tangential and some that seem to be more central, or do you think we're really left to, we list 6 factors and we kind of eyeball them and throw the case on one side of the heap or the other?
Yeah, I mean, I might tend to go with the order in which the settles factors are listed. And I think particularly in this case, when starting with whether it's a local regulation or absolute prohibition, I think that is quite determinative here. The long history of firearms regulations, particularly not just sort of, yes, that long history, but also since at least the 1968 police regulations, specific provisions that discuss transport of firearms. And again, do so in a way that's not an absolute prohibition. It says when you're doing it for these specified purposes, and there are a number of purposes, you have to do it subject to these conditions, and there are particular conditions. And that has, the district has modified that over time since. Police regulations exclusively prosecuted by the district, not by the United States. The Firearms Control Regulations Act also exclusively by the district, not the United States. So the history, and then getting into legislative intent, I think that is important, maybe not quite as important as the other factors, but here we have that clear and express indication of legislative intent, which I suggested would trump sort of where it happens to be codified in the code. And of course, we have the penalties being entirely consistent with what the unregistered firearm and unlawful ammunition statutes provided. So another clear indicator that that factor, again, favors the district. So hopefully that's some guidance there.
Just to put a pin on it, it's not as easy as just kind of counting up the factors and saying, well, it's they're 6 in all, it's 5 to 1, or 4 to 2, and
yeah, that's certainly true. And that's why I suggested before that this court should look to its other cases and sort of think about where this particular statute fits in the scheme of other statutes where this court has allocated or recognized U.S. Attorney's Office versus the District of Columbia. And here, as I suggested, this is much more like the solid waste disposal statute and the UFUA statutes than solicitation of prostitution, voyeurism. I think, there's 2 clear polls there, and we're certainly on the UFUA and solid waste side of that. I know I've taken up a lot of time, and I did want to allow Ms. Park an opportunity to speak.
Thank you.
Okay, thank you.
May it please the court, Ann Park on behalf of the United States. Applying the in-race settles factors of the 6 factors, 4 strongly weigh in favor of UT being a regulation prosecutable by the OAG, and 2 others provide some indication that it's a USAO offense. But I'd like to begin with the penalties provision. It's really not an issue here because in Hall and UF and UA, the penalty provisions are about the same. But Defendant Handy raised in his reply brief this notion of the general recidivist statute, and Mr. Schifferle has indicated that he thinks that OAG would be the proper prosecutor for repeat offenses. And I'm not ready to talk about all the cases Your Honor was addressing to him, but I just want to step back for a second and think about what this court is being asked to decide. It is being asked to decide whether this provision is a police regulation for purposes of 23-101A. The term regulation is bandied about quite a bit. It has many different terms, as your honor wrote in settles. But here we're looking specifically at what constitutes a police regulation for purposes of 23-101A when we have to figure out who is a proper prosecutor. And the penalty provisions are important because when you think about regulations, you do not think about 5-year prison terms. You do not think about 10-year prison terms. This court has said up to a year. That can be considered a regulation for purposes of 23-101A. So the fact that there's a repeat offender statute, whether it's in the specific provision that's at issue or the general recidivist provision, at some point, if you keep increasing the penalties, that cannot be a regulation. And Crawley states.
For sure, that's true. And I mean, it's interesting, right, that I think that the penalty, well, let me go back and say, I mean, I guess one question that I have really is about CPWL and why the United States doesn't want to prosecute the UT crimes, because it seems hand in glove with the CPWL provision and has been historically since 1932, right? So, I mean, it was always a defense to say you're transporting the gun properly to the 1932 statute. And so here we are, and I'm just kind of flummoxed as to why the United States suddenly is saying, oh, this is actually just purely regulatory. This isn't a penal statute. And I hear you that, it's only, up to a year in prison. Up to a year in jail is a long time. And, other regulatory offenses, you see penalties of up to 10 days or, $1,000 fine. So this has pretty serious consequences and again seems kind of a clear complement to the CPWL statute. So I wonder if you can explain to me the United States' position.
Sure, Your Honor. And the issue arises here is we're talking about unlawful transportation of a firearm as a standalone offense. Had there been, the defendant here actually had a license to carry a pistol in DC, so he was not charged with CPWL. Had he been charged with CPWL, there are provisions in 23-101 D and E that talk about when each prosecuting authority can consent to the others, when the offenses are joinable. So Hall was UF and UA. There was no CPWL charge. He wasn't charged with CPWL. They were standalone offenses, and hence the issue of who is a proper prosecutor arose.
Right. But had Mr. Handy not had a license, the United States would have gladly prosecuted him for CPWL and UT, right?
Yes, yeah. And we probably still can as long as the OAG consents. And there has been very much cooperation between our offices. I mean, it just makes sense to try all the joinable offenses together. We don't want to be trying, different offenses. So we've worked very cooperatively through the years. So that concern really is not an issue. And it's not that whether U.S. Attorney's Office wants a charge or doesn't want a charge. It's really, what does 23-101
Well, I mean,
say?
I say flipply once, but, clearly the United States has its own agenda for prosecuting crimes and in particular gun crimes. And the district has its distinct agenda, and sometimes those agendas align and sometimes they do not. And so I'm just trying to figure out why the United States would want to cede some measure of control over these kinds of offenses to the district. And I grant you that there's good cooperation between the offices right now. That's a good thing for the residents of the district, I think. But, that's not necessarily predictive or prescriptive. And, so.
My answer is, Your Honor, the United States did try to argue in Hall a lot of the arguments that Mr. Martorana makes here to restrict the reach of Hall. But your honors rejected our arguments, and we have in re settles.
On
If
those
you apply
facts,
this,
right?
yeah.
But do you think that this statute, the UT statute, is different for some of the reasons that I was discussing with Mr. Schifferly, that you know, we are talking about the transportation of guns, not the mere possession of an unregistered firearm. We're talking about moving it around, you know, maybe from one place where you're allowed to lawfully have it to another place that you're allowed to lawfully have it. And sure, you're in the district possibly momentarily while you're transporting it, but you know, it's possible to be in the district for mere minutes and then be in the state of Maryland or the state of Virginia. So
Yes, Your Honor. You know, the distinction Mr. Appellant makes in his brief about local versus national concern, that's really not a factor that this court talks about. When it's talking about local regulations and designed to regulate in accordance with local conditions, it's comparing that to absolute prohibitions or general prohibitions. There's no language, and I think Mr. Appellant is really importing that because of the history of this particular provision that it relies on a federal statute dealing with interstate transportation. But it's not national concern versus local concern, and they're certainly not mutually exclusive. There are a lot of local things that are regulated with local conditions that are of national concern because, quite frankly, most jurisdictions are worried about the same exact things. It's part of the human condition to regulate waste and traffic offenses and transportation of firearms and transportation of lots of things. And those can be of national concern, but that doesn't mean they're not local in character either. The case law, when you talk about the first factor of settles, is not about whether it's national or local. It's about whether it's regulating local conditions. And the first factor in settles, I think, weighs very strongly in favor of OAG being the prosecutor in this case, as well as the second factor. This is exactly a time, place, manner restriction. You're not prohibiting it entirely. Indeed, you couldn't. People have to get their guns to where they need to take them. And just telling you, when you do transport a firearm in a vehicle, here's how you have to do it if you are in DC. And sure, DC relied on, and it's a very good policy decision, I think the council made, relied on the federal statute to kind of make things consistent between states. But at the same time, DC Council, in its discretion, can regulate and add conditions based on the local unique character of DC, and so can other jurisdictions. So the case law, I think, on this first factor weighs very heavily in favor of OAG being the prosecutor. And when
one aspect of that, because I mean, I take it a part of your point, but I wonder if another part is overstated. At least in settles, there's a component of settles that is more about geography in a sense, because one of the things that we said in settles was this is really local in that some places in DC you're allowed to do this activity, other places you are not. So that makes it very localized. And that was, I think, less like what you're talking about and more about it really, this was geographically tailored in a way that means that it was, you know, is special to DC and parts of DC. That doesn't really have an analog here on the one hand. And also, I do think it is, that is an aspect of the way we were analyzing this first factor in settles that did focus on whether something was like a generalized prohibition everywhere or a generalized requirement applicable everywhere and a requirement that was more narrow in its geographical focus.
I think it's just the nature of the regulation there. It's dumping versus here we're talking about, it seems like each regulation, you're going to focus on different aspects of the definition of what is a local regulation and an absolute general prohibition, depending on, it would seem to me, the nature of the conduct that's being prohibited. The statute here, just when you're in DC, this is how you have to contain the firearm in your vehicle. That seems to me less able to rely on this. You can dump here, but not there, because anywhere in DC, as long as it's done in the correct manner, you can take your vehicle in the car.
Right, but I mean, this case would be more like settles on the first factor. I guess my point is, I'm interested in response to it. I mean, if the statute here said, if you're on a local street in DC, you have to carry your gun this way. If you're on an interstate highway just traveling through, then we're not regulating you, and you can rely on it. You can do whatever you want. We don't really care if, as long as you're just on an interstate and going through and not stopping, it's fine. Then it would very much feel like it was kind of a local regulation about how you can do in some places in DC rather than other places in DC certain things. This doesn't have that feature that there was extant in settles, and it could have in theory, but it doesn't.
No, but I think that would have been very difficult for the vehicleists. I mean, I don't think that would have been a great policy decision on the DC Council's part, but I think that's.
Completely agree. I'm just kind of
Yeah.
exploring the logical
Yes.
structure. of
And
the
I think
cases.
the fact that this is less like settles in terms of geography doesn't preclude it from being a local regulation. That is to say,
I agree with that too. I was just, at times it seemed like you were saying it's really not part of the inquiry, the first part of the
No, I'm
inquiry,
saying it
whether
can-
it's local or
no, it can
national.
be. I think it just depends. It depends on the regulation.
Can I ask you a question about the legislative history factor, where I think the idea is the fact that we know the council made, declared its intent about who will be, this is a standalone crime and who's going to be the prosecutor, shows legislative intent. But it seems so kind of analytically entangled with the like lack of authority for the council to say who the prosecutor is. Like, and in settles, the United States argued that this stuff was irrelevant, right? Now it lost that argument, but why isn't it the case that the problem with the council saying this at all also kind of taints or nullifies the probative value of its statement?
The government's argument in Hall or settles was, I think we're thinking about legislative intent in two different ways. The government was merely making the argument under 23101C, which is the except as otherwise provided provision. And in Crawley, this court said only Congress can legislate exceptions to change the division prosecutorial authority under 23101A and B. And all we were saying is the fact that the council has said the OAG is a prosecutor means nothing, because a lot of those have been invalidated because they went against Crawley. The issue here, and the court came back and said, well, we don't think it's irrelevant, because for the issue here, we weren't deciding 23101C cases. It was 23101A. Can we fit this provision as a municipal regulation or a general penal statute? And that's going to determine, in this instance, who the prosecutor is. And what the legislature's intent is in terms of what it thought, whether it's a regulatory offense or not, is attached to who they thought the prosecutor would be. So in settles, actually, there wasn't a provision in that statute that said, that is as clear as says the prosecution under this provision shall be done by the OAG's office. There was no such provision. So this court went to the legislative history, and in the legislative history, there was testimony by, I think, a Department of Public Works official or employee. And she said, well, this provision, she talked about why she thought it was necessary. Everyone was dumping everything in DC. And she thought these provisions would be prosecuted by OAG, because in her experience, these regulatory municipal waste prosecutions were handled with OAG. The court said, well, that's a factor this court can consider, because the council thought that these cases would be brought by OAG. So it shows that they thought this provision was regulatory in nature. And that is the extent, or my understanding, of what legislative history means in that factor. It's very narrow, and it only pertains to 23101A when you're trying to decide whether it's a regulation or a penal statute.
So is it fair to say then that essentially what you're doing is saying, we're trying to glean how the council thought, which hat the council thought it was wearing when it enacted this provision, right? And so we can glean from the fact that it said the OAG should prosecute this, that it thought that it was acting in its regulatory authority.
That it was enacting something that's more akin to a regulation.
Enacting something that's more akin to a regulation. However, we also can look to the fact that it says that it's amending a provision of Title 22 to signal in the opposite direction. And so it seems like maybe in this case, the legislative history aspect cancels itself out. I mean, I just don't know how to weigh unless you want to make a pitch to me that one of those things should be weighed more heavily than the other, it seems like they negate each other.
I will say, I mean, in this case, I think of the legislative history and the codification kind of together.
I mean, they're both
They kind of
indicative of legislative intent, right? It's just that they point in diametrically opposite directions.
Yes, and I would just say here, Title 20, I mean, it makes sense to put UT in Title 22 because it was the language and it historically it has been defense to CPWL.
That's
But-
where I want to go.
Yeah. But,
Yeah.
but I'm just saying in terms of codification, it could very easily have been placed in Title 7 as well, because Title 7 actually refers to the UT provision in Title 22. There's quite a bit of
I mean,
cross-referencing.
maybe, shoulda, woulda, coulda, but the council didn't do that,
Sure.
right? And I thought we decided we're looking at the, where it's placed in the title or what the council said either in a committee report or, actually in the statute, designated that we're just trying to figure out which hat they're wearing.
I don't think the question comes down to which hat the legislature is wearing.
What hat they think they're wearing.
Or what hat they think they're wearing, because I mean, this court has an independent duty to kind of look at this is a matter of statutory
This
interpretation.
is within our.
Yes, within your
our
purview.
framework.
Yes.
We are looking at the settles factors. And why do we look at those two factors? Because we care what the council thought
were
it was doing.
Yes.
And those two factors give us some indication of what the council thought it was doing, except that they seem contradictory. Can we, unless you have another point on this?
I would just say, I think the most important factors, and this is based on how much discussion the court does of these factors in Settles, Hall, and all the earlier cases. I mean, the history, or whether it's a local regulation or absolute prohibition, whether it's the history of enforcement and prosecution, those seem to be really important. The penalty provisions seem
We
really
go
important.
to the
Yes.
history of the enforcement and can you explain to me why the United States thinks that this favors OAG prosecuting UT? Because it seems like the United States occupied the field for decades, right? I mean, there's the
Say defense to CPWL.
well, but regardless, like it is the United States that is prosecuting these offenses and then saying, okay, you cannot be convicted if you can show these things. I'm not sure that it matters that it was a defense. It just shows that this was an area of particular concern to the United States and the local authorities said nothing, did nothing about it as far as we can tell. They enacted the 1968 regulations decades later.
But it was the first time it was a standalone offense. I think that's.
I don't think it was a standalone offense in
was,
1968.
Yeah.
I think it just mirrored the defense.
No,
There's a provision.
There's a
I'll go
provision.
back and look, but regardless, that is.
Section
that
8A is
first-
more of a defense and 8B is actually a standalone provision, is my understanding.
Okay,
when I
but
read the regulations.
that lasts, till 1975? When it's
yes, when
76?
The FCRA was enacted in 76.
Right, and so it's, fleeting, and I can't remember if it's in Hall or in Settles where we talk about, the government was making some pitch about an 8-year time when they did something, and it seems very much like
Yes, but
that
the
where
court
we.
rejected that.
But
Yeah.
my point exactly of kind of saying, well, we said 8 years wasn't much of a history of anything, and that seems to be what everybody is resting on. I mean, it is the case that it really doesn't, UT does not come into being in its current form until 2018. At
2023.
2023, sorry, I
20.
have all my years wrong. I'm not to be trusted on years, but the point being recently. So it's hard to see that there's this historical record of regulation and enforcement. It really seems like this is something that the United States has been doing for a very, very long time.
No, Your Honor, and maybe Your Honor does not think this is a big distinction, but in the United States mind, there is a big distinction between something being an affirmative offense and making something a standalone criminal offense that attaches its own penalties. There's a difference between creating a safe harbor for certain conduct versus making that conduct criminal in and.
I definitely think there's a big distinction between the two, but my point is that even as the United States was creating this safe harbor, that it wasn't that local officials or the police regulations were going into the vacuum and saying, okay, now we're going to prosecute this conduct. That just didn't, it's like the dog that didn't bark, like, you know, it didn't happen. And it was just that the United States was saying, okay, we're regulating guns and we're saying that we're not going to convict you if you're transporting guns under these conditions. And that was the universe for a
And
really,
Congress-
really,
wait,
really long time.
In Congress in 1932, when Congress was before the Home Rule Act, Congress could have enacted their own standalone provision of UT. It chose not to in its discretion. And I think it's hard to, I mean, I can't tell you why the district didn't act or why Congress didn't make these statutes. I mean, they didn't think it, I guess that just didn't seem to be a good idea back then. I'm not sure, but I do know what we do have in terms of the history. And all we have
ask you before-
is the
I just
1968.
want to put a little, we've been talking about this factor in the context of sort of exact UT regulation. And there's also a line of discussion in some of our cases and in the arguments about, well, maybe the history can also be more thematic in character. And the issue is sort of, is there a long history of regulation in the area? But that also seems a little bit mixed because there is a long history. We acknowledged in Hall, for example, of regulatory activity by the district in the area of firearms regulation. So if you're looking thematically, if you're allowed to look thematically, that's aspect of the factor could be viewed as favoring the district. But there also is, speaking thematically again, a long history of U.S. Attorney's Office prosecution of criminal offenses in the firearm area. So if you're thematic, it sort of seems like there's a history on both sides.
There certainly is. And Maryland Pistol addressed this, and it's the gun control regulatory scheme has a federal aspect and a DC aspect, and it's confusing and it's overlapping, but that's okay. I mean, that happens in a lot, not a lot. DC is unique, but it happens. You have municipal bodies overlapping with state, filling in the gaps, overlapping a little bit. But the issue here is, and I don't see appellant making any sort of preemption argument. The fact that there is this dual system doesn't mean, I don't know, it makes it a little difficult for us to decide these questions because of the uniqueness of DC, but I'm not sure it really is either here or there, because no one disputes Congress's ability to do what it did, and no one disputes the DC Council's ability now under the Home Rule Act to create new laws.
I'll ask you, I guess you started off your argument by, I think, getting close to saying, but I'm not sure you unambiguously said, so I just want to make your position 100% clear. On the issue of whether someone charged with a violation of UT as a repeat offender who faces 2 or 3 years incarceration under the prosecution, is it your view that the U.S. Attorney's Office is the appropriate prosecutor or that OAG would be?
U.S. Attorney's Office, Your Honor. I just think the definition of a regulation under any sort of definition, once you start approaching years of imprisonment. A year is, as Your Honor said, is a long time, but this court has said a year is not enough to push it over to the edge.
And
but I think
I also wanted to make sure we got your position explicitly about misdemeanor CPWL. I assume what your answer will be, but I just want to make sure we get it explicit. And if you were asked the question about why UT is theirs and CPWL misdemeanor, well, CPWL is yours. The history of prosecution is one. It sounds like for your position, dual prosecutor is the same for both of them. That's a problem that could arise. So do you have any other distinctions between them, or is it really all the history? Is it really all history?
It's history. I think also CPWL, I know both Mr. Schifferle and appellant seem to think that it's more on the side of regulatory versus prohibition, but I think it's more of a prohibition. I understand there's a lot of exceptions in it, but it says you can't carry a pistol in the in DC without a license. And it's the same as UF and UA. And one could say UF and UA are more, I guess, absolute prohibitive. But along with the registration, there's a huge regulatory screen. And certainly with the licensing, there's a huge regulatory screen. But I think the actions they prohibit are actually pretty general. And you could say UF and UA should be ours by that token if you're relying solely on the first settles factor, but the history of UF and UA, the long history of it and the unique history of it being the precise same regulation then being enacted into the code when at the time when the DC Council did not have its legislative hat yet. That makes that, and historically it's always been prosecuted by OAG. That's the same, I think that's the same place I would lie. It's the history, and CPWL was enacted at a time when Congress was the legislative body and Congress was making criminal offenses, and they could have under 23101C accepted the U.S. Attorney's Office for misdemeanor CPWLs. They certainly accepted and made exceptions for OAG to prosecute in other criminal offenses, but they chose not to. So I think for all those reasons, CPWL is squarely in our camp, so to speak, and I don't think anyone disputes that.
Ms. Park, say hypothetically, we have a case where you go through the settles factors and every single one of the factors is a wash. I mean, there's just no clear answer on any one of them. Do you think that the structure of 23101, where it says that kind of the U.S. Attorney's Office is the default prosecutor, would signal it would be a factor in us deciding that we should go, because we cannot decide, like the factors in my hypothetical, all of them are a wash, right? And that's how I read 23101, is that there's carve outs for OAG, but for everything else that doesn't fall in with a fall within a carve out, you look to the U.S. Attorney's Office. Would we revert to that and say it's the U.S. Attorney's Office responsibility?
Your Honor, it's kind of hard for me to answer that question in the abstract because I just can't see how one would be a wash on all of the factors.
But in my hypothetical, it is.
I don't know, change the statute.
Or to take a friendly amendment. It also could be, instead of each one being a wash, it could be that when you added them all up, it seemed like you were in equipoise. So that might be another, maybe more likely scenario.
Variation on a theme.
I suppose the structure of 23101A does seem to indicate everything else is the U.S. Attorney's.
That's in C. I mean,
That's in C.
everything else is in C.
Yeah,
A just says if you meet a criterion, it's DC.
Your Honor, I think I have to say that's the court's job to decide what little grain of sand goes on the other side to the other side.
ask
I mean,
you,
it's statutory interpretation here. We make our best pitch. We look at all the tools we have, and then the court decides. If the court wants to come out and say we're in equipoise, we don't know what we want to do. I guess that's one thing, but I've never seen that before, ever. Judges usually can decide.
Well, let me ask you, there are at least two other possible tie-breaking ideas one could have in mind. One would be that you would assume that the legislature, I mean, if the legislature has made clear by, let's say, enacting legislation what it wants, you could say that if you really can't, unless there's some reason, if you, at the end of the day, you're not sure whether it's okay or not okay, there are like presumptions of legality or something that could be a tiebreaker. That's one possible theory. The other question is, I mean, does the Home Rule Act fit in as a possible tiebreaker about whether we should be deferring to the city council about what it can do? Although our Home Rule Act cases about deference on that are themselves, I find somewhat confusing, because really you're balancing the authorities of the city council and the limitations imposed by Congress. So, I mean, there are other possible tie-breaking principles, but do you have any view about whether any of those, whether the Home Rule Act or presumptions of legality might be tie-breaking principles, or you're not sure?
Not sure, Your Honor. I really haven't thought about it enough. And for this case, I think the factors weigh heavily in favor of OAG being the prosecutor, if you go through them. And especially the ones that the court in its case law seems to find more important, the factors do weigh in OAG's favor. And that is the reason why applying the settles factors faithfully, we think UT is OAG's in OAG's camp, so to speak. So we ask that the court, if there are no further questions, remand to the Superior Court and proceed with the prosecution with OAG as a prosecutor.
You, Ms. Park. Mr. Martirana, we will give you 3 minutes for rebuttal.
Thank you, Your Honor. So just to pick up on Judge Easterly, what you said about to Mr. Schifferly about what the council said in the actual ghost gun enactment. They did break it up and they said, we're going to do Title VII here and we're going to amend it here. And then Title 22 and the Dangerous Weapons Act is amended as follows, is the exact language that the council uses. You can find that, Judge, at DC Register 70 at page 932 and 933. In that light, taking this and putting it in Title VII would not necessarily be dispositive in the general sense, but in this particular case, given what they did, what the council did, they were distinguishing between two. And so if they could have put it in Title VII, they could have put it in Title VII. But then again, that doesn't necessarily trace as dispositive because there's no long history of regulation that can be traced back to anything but the Dangerous Weapons Act of 1932. I do want to address Mr. Schifferly's point that he wants to start with local regulation versus general prohibition. And what Judge Blakely said on page 238 of the settle's opinion, where he says the police or municipal ordinance or regulation must be, that phrase must be read very, very narrowly. So going back to the point, if all of these factors are awash and it doesn't necessarily fit within that, then it does default to the U.S. Attorney's Office. I want to address one thing that Ms. Park did say. She talked about whether or not if the problem is somewhere else in the country, that doesn't necessarily make it a local regulation. But I do want to point out the language of Moynihan and the Sella case that came before that in 1911. A local regulation or police ordinance is something that is peculiarly applicable to the inhabitants of a particular place. That is the way that the court has defined what a regulation, police regulation or ordinance is. And this falls into this particular offense is aimed at conduct. And it doesn't fall neatly into either one of these boxes. On the one hand, it does seem to regulate the way you carry the firearm, but the way it's also prohibitory in another way because it's just as much against public policy in the district as it would be, as Your Honor, as Judge Easterly said, in Idaho. And I would just point out a brief hypothetical that if a victim is in a park in DC with their own kid and somebody's driving around with a loaded firearm and it's bouncing around and they're hitting potholes and the firearm goes off and kills the kid, does the victim care whether that's in DC or whether that happens in a park in Idaho? That is why this is not a local concern. This has to do with transportation of the firearm and it has to do with interstate. There's a standardized statute out there in 926A that talks about how you do it nationwide. There's other states, and I see my time has run out, but just briefly, there are other states that have done the same. New Jersey statute annotated also has done this. It's 23.4-24-1A has also said that we're going to penalize the transportation of the firearm if you don't do it in the correct way. So that makes this a nationwide concern rather than a local concern. It's not peculiar applicable. It's not a local regulation. And this statute that we're talking about, 22-4504.02, is a part of a whole enactment from the Dangerous Weapons Act. It's been there for 94 years. These offenses have traditionally been prosecuted by USAO. And as Judge McLeese said in the settle's opinion on 238, you have to worry about the consequences of a given interpretation. And the way I understand OAG's argument is they say they collapsed the two tracks of regulatory function here in the District of Columbia together to say, well, we have a long history. And because we referred to it in the 1968 police regulation, it somehow belongs to us. They can say the same thing with CPWL. because there is a provision in there. They could say the same thing with shotguns, because there's the same thing in the 1968 regulations that talks about a prohibitory effect. And they can say, well, because we did it in 68, even though there's no traceable conduct to this day or traceable legislation to this day, we can still use our general legislative authority because we fleetingly referenced it in the 1968 regulation to encompass both CPWL and carrying a dangerous weapon as well under 4514B, because you're regulating conduct there too as well. You can't have that stiletto. You can have it, but you can't use it in an unlawful way. So I think the balance of the settles factors and and where this is codified in Title 22, the long history of this being a congressional act defaulted to the USAO for the prosecutorial authority. And we ask that this court find that prosecution authority belongs to USAO. And one last thing, if you could just say, I know there's no controversy with respect to the presiding judge aspect of this, but it did take a while to get here. And so I would hope that the court could say something about, in its opinion, about defining the term presiding judge and whether that includes the magistrate, because a lot of these cases are going to originate in that magistrate court. Thank you very much.
Thank you. Thank you all for your arguments today. The case will be submitted. The second and final case on this morning's, it's still morning calendar, is number 25 FM 607, Fonda Allen versus Tamika Whitehead.
Good morning and may it please the court. My name is Laura Foggin and I represent the appellant Fonda Denise Allen, a custodial grandmother. And Pamela Sonsini is here today as well, who will represent the district and argue for 5 minutes on legislative intent and the broader impact of the case.
Thank you.
The question presented is whether a custodial grandmother and the biological mother of the children who retains court-ordered visitation are family members within the meaning of the Inter-Family Offenses Act. And the answer is yes. That result is compelled by the plain language of the act, its remedial purpose, its legislative history, and the need to avoid arbitrary and unconstitutional construction. The Superior Court dismissed for lack of jurisdiction by reading critical statutory language out of the act, and that dismissal should be reversed. The Inter-Family Offenses Act permits intimate partners, such as spouses and domestic partners and household members, as well as what it broadly defines as family members, to seek non-criminal remedies for interfamily violence. Under the Act, a family member is a person to whom the offender is related by blood, adoption, legal custody, marriage, or domestic partnership.
The statute says or. It doesn't seem to envision stacking these relationships, as I understand the argument for Ms. Allen goes, right? That the relationship here is there's a legal custody relationship between the paternal grandmother and the child, and there's a blood relationship between the child and the mother. And so ergo, there's a family relationship between the paternal grandmother and the mother, right? But that requires stacking the legal custody and the blood relationship to get there, right?
Respectfully, Your Honor, no.
Okay,
We
tell me
think
how.
each of those
to think about it.
relationships independently support jurisdiction here. And the words related
The
by,
CP, I'm sorry, I'm just not following that. I thought that's the paternal grandmother trying to get the CPO against the mother as a family member.
that's absolutely correct,
Right.
Your Honor.
and there's no blood relationship between the paternal grandmother and the mother directly. Right? That it's the paternal grandmother and the woman with whom her son had children.
I agree, Your Honor, and
Okay.
I'll just comment that your question includes the word directly, something the statute does not.
Well,
include,
but
we
that
think
gets to
is
my,
important.
that's why I was tracing the relations, right? It's indirect. It's I thought, but maybe I'm still not understanding. You're relying on the paternal grandmother's legal custody relationship with the child and also, I mean, potentially blood relationship with the child, right? I mean, so, and then the child's relationship with the mother to get the family relationship between the paternal grandmother and the mother.
Your Honor, no.
Okay, I'll listen.
I'm relying on each of those things independently to doubly
Independently
qualify.
doesn't get you there, right?
We believe it does, and here's why.
Okay,
Ms. Allen has court-ordered legal custody of the children. And under that custody order, Ms. Whitehead retains parental status and court-ordered visitation.
But she doesn't have custody, does she?
She does not have custody. She has residual
Understood.
parental rights and
For sure,
visitation.
For
rights.
sure. But so
That's
if you're saying
important.
directly, so if you're saying Ms. Allen and Ms. Whitehead are related by custody directly, what custody does Ms. Whitehead have?
So, Your Honor, you've also added the word directly into.
I'm just asking first, because you said, I thought you said that you could do it directly and here was how. And I'm just asking if you're focused on custody first,
Yes.
how are they related by custody if only one of them has custody?
Because what the statute says is that a family member is a person related by legal custody. It doesn't say a custodian. It doesn't say one adult must have a custody of the other. It says the adults must have a relationship.
Agreed.
related
And so
by legal
I think
custody.
if you had two co-custodians, so there are two people who had shared legal custody of a child, I would think you could say they're related by custody in that they each have custody over the same person. And that one wouldn't have custody over the other, but they would be in a very direct way related by custody. I get that. You could draw right, you could say they're related by custody in that they have custody over the same person. That's not the situation here. So if these two people are related by custody, it's a more complicated relation than that they have custody of the same individual or that one
Not
has
the
custody over
same.
the other. And the question is, what kinds of connections of custody are enough to make two people related by custody?
And the answer to that is that there is a custody order here that creates a continuing enforceable legal relationship, not just to the children, but between the two adults that is maintained and supervised by the court. They must coordinate visitation, exchange the children, comply with schedules, and resolve disputes.
if there were a custody order that said that the teacher of a child had to make the child available at a certain time once a week for family therapy, would you say that there's a custodial relationship between the teacher and either one of the parents? That seems like an overbroad reading of legal custody to say just because the custody order dictates certain activities by a certain person, there's a custodial relationship, right? Generally, when we think legal custody, we think physical custody, right? Legal custody. It can be joint, it can be sole. In this instance, my understanding is the paternal grandmother has physical and legal custody of the child and the mother does not.
That's correct. Here, I don't think it's just a question of the custody order providing some provision. The legal custody, the fiscal and legal custody awarded to the grandmother is, of course, subordinate to the ongoing parental rights and responsibilities of the mother. That's written in the custody statute. So the mother stands in a different position than a teacher who might
For sure,
have
but
to
this
take a
is getting
child
me
to
right
therapy.
back to where we started, where I said the mother has a relationship with the child, right? The parental rights have not been terminated, and there is a blood relationship that is still legally recognized, even though the mother has neither legal or physical custody of the child. Accept that. I accept that. But the relationship, and there's a relationship between the paternal grandmother and the child. It seems to me that you were stacking, that you were going from the paternal grandmother to the child to the mother. And I go back to the words of the statute, which says or, right? It doesn't say and.
I understand that. We're not stacking. We have a different reading of the words of the statute and particularly the key phrase related by. And I would call to mind, other statutory interpretation by the court. There's a case that involved unemployment benefits and whether the conduct of the offending conduct was due to domestic violence. And in that case, the court made very clear that it would not read into the statute a requirement of directly due to, only due to, solely due to. Due to is a broad phrase.
Can I ask you, I mean, if you were assuming that the connection doesn't have to be direct, and so that you can say person A and person B are linked by an order that creates custody, it seems like you don't think that a teacher or let's say an employee of there are a bunch of related hypotheticals you could spin out. I'll just list some of them. An employee of the DC government who had physical custody of the child for certain, during certain parts of the time, or a judge who issued a custody order. Those are all people who would be related to, let's say, the actual physical and legal custodian by a custody order. But I think you're saying you don't mean that kind of, that's not the right kind of connection. Or would you agree that none of those people could get a CPO against, let's say, an unhappy person who had full legal and physical custody under the order?
Not the question before us today, but I think that it's unlikely that they would qualify.
And what's your limiting principle? What's the limiting principle?
The custody statute itself says that when custody is awarded to a third party, a custodian, it is subordinate to the residual rights of the parents.
Which don't include physical or legal custody.
Which don't include physical or legal custody, but they do include visitation and they do include a requirement.
They may or may not include visitation. They may or may not include visitation, depending.
And let me focus on those words related by.
Yeah, before you do, I want to frame a question for you about that, because in some contexts, related by is a very broad concept. It's in some ways, one could say anything is related to anything else in some way of relation. So it's a somewhat limitless concept with no context. But it's an ambiguous term here, and I'm just wondering whether you think that it is right for us to construe that related by to mean connected by, or whether you think related there means a relative, becomes a relative of, because people are related. You can say, if you could say two people are related, you and I are related because we're here at this argument. I'm a former lawyer, you're a lawyer, lots of ways in which we're related, but we're not. No one would think we are family members in a normal sense of that term. And so I'm wondering whether you think related by should be understood under this statute to mean has a connection of any kind, subject to whatever limits you're suggesting, or whether it really means our family. Why should we be adopting the broad view of related rather than the narrow view of related, meaning they become family?
I think it's the plain meaning of related by is the connected to meaning. And I think
why is that? Well, you do agree that, if someone said, are you and I, if someone walked up to Judge Beckwith and I and said, are you related? I would probably not say, well, we have connections of various kinds. I would think that was a question about whether we were family in some way. And I would say we are not. So I don't know that I think plain language will tell us whether what is meant here is the family sense of related or the generalized connection sense of related.
So it certainly doesn't mean the direct sense of custodian. And here's why. The statute includes family members. Family members includes people related by marriage. That's one of the categories of family members, marriage, domestic partnership.
Certainly, and I think in normal parlance, if somebody asked me if I was related to my brother-in-law, I might say, well, not by blood, but yes, we're relatives through marriage, where that my brother-in-law is part of my family. So I'm
know
not sure that is
related
a counterpoint.
Marriage does not mean spouse, does not mean the direct relationship of one spouse to another. And we know that also because intimate partners already include spouses and domestic partners under the act, and therefore related by marriage, we have to assume is expanding, not contracting the definition of who is a family member and who is included. So therefore, we know related by marriage does not mean one to the other. And similarly, related by legal custody does not mean just the custodian.
That's true, but I don't know that that tells you the answer to the question of whether when figuring out what more it means than that, we should be just thinking it means connected in the general sense, or whether instead we should be thinking, well, who essentially becomes part of a family in law or biology in virtue of these custody orders. I'm not sure that answers that question, but if you think it does, I'd be interested in why you think it does.
Among other things, I think if the court believes there's ambiguity in the words related by, then there are other things to look to resolve this question. And one is certainly the purpose of the statute, which is protective and remedial. And this court has repeatedly
It's
stated.
not protective and remedial against all the world. It's protective and remedial in the intra-family context, right? And so we're trying to figure out what family is. We've got this definition of family member, and it's someone to whom the offender is related by blood, adoption, legal custody, marriage, or domestic partnership. I'm getting back, I guess, to Judge McLeese's question of why shouldn't we think that related by means is a relative of, by virtue of blood adoption, legal custody, marriage, or domestic partnership, rather than a broader conception of has some connection to that then might need some limiting principles grafted onto it because, as Judge McLeese has now explained, connected to could lead you in all sorts of places.
Connected to does have limitations. It has limitations in the statute. It doesn't say
What
someone
are
to whom you're related writ large. It says someone to whom you're related by marriage, adoption, legal custody, domestic partnership, etc. So you have to show a specific link. And with respect to legal custody here, we actually have a court order, which includes both parties in the same order, forced to interact with one another.
Right, and in a hypothetical, well, I get, other than the last part, actually even the last part, if I was a trial judge and I issued a custody order, I mean, my name is on the order. I'm the one who created I created the legal custody. So I couldn't have a more direct relationship to this custodial order and the people who are subject to the legal requirements on whom I'm imposing them. So why would I not? Maybe I would. Maybe your answer is I should be able to get. I mean, if I ended up having a problem where I was alleging that someone who was under a custody order of mine was acting in a way that would be regulated by the CPO statute, maybe I should be able to get a CPO. Maybe, but is that your position? And if not, there's some other limiting principle going on. I don't know yet what it is.
Yes. Okay. So I've tried to answer that question again, but let me try one more time, which is a different person who may be named in the order does not stand in the same relationship to the legal custodian as the parent. And that is clear from the custody statute.
And what relation where do you get the limitation that if you're using the phrase related by to mean is connected? It would seem like, and lots of connections would do, including I'm very connected to the custody order in the hypothetical where I issued it. But you're saying, no, the connection has to have a specific character that doesn't include the trial judge. And it seems to include more of a family feel to it or something, but I don't know that you've articulated yet. And we've interrupted you as you tried, or at least I have. So I want to give you ample chance to do it, but I haven't yet figured out what the conceptual line you are drawing between and where you're getting it from. If we're supposed to interpret related by to mean connected, if that's all it means, then I don't know why the judge hypothetical is out. So I think you're saying it means something more. And if you could just tell me in terms like connected by here means ... More, related by means more than just connected. It means connected ... What the ... is would be very helpful to me.
Okay, it means connected by legal custody. And when we look at the code 16-231-21, the definition of legal custody says, as the court has already articulated, legal custody, a legal statute created by a division order which rests in a custodian responsibility of custody of the minor, which includes physical custody, right to protect, responsibility to provide the minor, blah, blah, blah. A division order of legal custody is subordinate to any residual parental rights and responsibilities. And that shows that the
Right, but the
parents
family
may have
member
been
statute
unique.
doesn't say family member means a person to whom the offender is related by residual parental rights, right? It says
by
related by legal
custody.
custody, but legal custody is defined very specifically. It says it doesn't affect these residual rights. So it would seem for your direct relationship to work that the statute's missing some language about residual parental rights.
I don't agree, Your Honor. I think that the related to language really is the key language, that it's broader than the court has proposed to read it, that does not mean a relation, that it is used in a plain language context, plain English context, suggesting a connection between the offender and the respondent.
I thought
and
you were
that
putting
connection
weight
must
on the
be-
legal custody, and right, like this seems less about what related by means and what legal custody means, because you're sort of saying, well, this concept of legal custody also incorporates the residual parental rights.
It does, Your Honor, but the related by connected to the two adults needing to interact pursuant to legal custody. And I think the same is
If
true.
we disagree with your conception of what legal custody means, do you have another argument?
We do, Your Honor, and that is that the parties are related by blood. And that also goes to this question where some of the earlier questions from the court included this word direct. And clearly the word direct does not appear in the
Right, so
statute.
explain to me then how the paternal grandmother is related to the mother of her son's child by blood.
So the statute does not limit related by blood to persons who share DNA with each other. It uses the broader phrase related by blood without qualification. And in ordinary usage, blood relations include not only first degree relations, but others who share blood with one another and extended family relationships that exist because of shared blood. Here,
I'm still not understanding. How do you think the paternal grandmother is related to the mother of her son's child by blood?
Ms. Allen and Ms. Whitehead both stand in direct blood relationship to the children.
So this gets back to my connected. It's by blood by virtue of the grandmother to the child to the mother.
By blood.
But
Indirectly.
you have to go through the child to get to the blood relationship.
And the statute doesn't say related without reference to a third person. It doesn't say lineally related. It doesn't say directly related. It says related by blood. And here, that reading of related by blood recognizes that the relationship of these two individuals to one another exists because of shared blood.
I just want to ask you a hypothetical. So the grandmother is related to the child, who's related to the mother, who's related to her sister, the mother's sister. Is the mother's sister a family member of the grandmother because they're all related by blood?
There's going to undoubtedly come a time where a kinship relationship is far enough removed that the court would find.
How do we know when
wouldn't
we've reached?
qualify?
How do we know when we've reached that point? And why isn't it just the grandmother to the child is and the mother to the child is the end of the relationship? Why do we get to draw lines?
We get to draw lines
I mean,
because
multiple lines.
two lines. We get to draw those lines because here, the relationship clearly can be indirect. And we know that from the way the statute is created with other categories. So we know that related by marriage does not mean spouse. It means go through the spouse to someone else. That's what it means, because spouse is already covered as intimate partner. So related by marriage is meaning
Well,
the brother-in-law, the
Intimate
sister-in-law,
partner
the
came
son-in-law.
later, right? I mean, it might be overlapping with spouse.
I think
right?
it's very
That
clear
could
from the legislative history
encompass
that
somebody who's, not married, but in a long-term relationship.
I think it's very clear from the legislative history that it's not overlapping, and that the intent of the council was to expand the definition of family member. And specifically, among the things that the council changed was a limitation which had stated offenses by a parent, guardian, or other legal custodian against a child as a separate category.
Can I ask you about this? And I'm not sure if I've missed this thread here, but the mention of intimate partner, the B part of what family member means. Do you think that the council intended B, who, family member means a person who is the child of an intimate partner, to add something that is not covered by A? And if so, how is that different from sort of the point of attenuation of the relationship between Ms. Allen and Ms. Whitehead?
Right. So I think it's possible. I mean, we can imagine a situation where there's no marriage, there's no, ongoing current relationship, but there is a child of an intimate partner, perhaps from another relationship. And so the question is just, that's meant to be included, period, and the council included it. But the other language in family member, very clearly, if you look at the legislation of the legislative history of the act, was intended to broaden the Interfamily Offenses Act and to make it fit families in the District of Columbia, which are not always traditional nuclear families, which often involve grandparent caretakers, and which need the remedies of the Interfamily Offenses Act.
Can I ask you how, you said, I think at one point that you thought that it sort of a common law, or there's a general understanding that your relatives can include extended family. So it might be perhaps that you would say, if someone said if I have a grandchild and someone said, is that grandchild's biological mother, not my child, part of my family, I might say, sure, part of my extended family, not direct, we may all be related by blood and DNA at some levels, but not in what we would normally think of as family because of our direct connections, but in that indirect way. I know there are a couple out of jurisdiction cases interpreting statutes like this in various permutations, but if you were trying to support the idea that there's sort of a general common law understanding that family can often include extended family, not really only biological kin, not necessarily even only people, even in-laws, but it can be more expansive than that. Is there some place you would point us to as supporting that family, that general understanding or concept?
I think there are a number of places. Now, with respect to the blood relationship, Your Honor alluded to the fact there are cases in Massachusetts, in Connecticut, and in Pennsylvania that involve this exact situation, a paternal grandparent to a parent, or a maternal grandparent to a parent on the other side of the lineage, so to speak, having found them to be related by blood and within the jurisdiction of those states' domestic violence laws, and did so in recognition of precisely this concept that there are broader family relations. And I think the other place to look again is the legislative history, where the council clearly said that it was elevating substance over form in finding these, in making these changes and in creating this definition of family member.
Can I ask you, this is a change of topic, but back on the definition of intimate partner and how it all fits into the picture. There is a subsection C of the definition of intimate partner refers to people with whom the offender has a child, someone with whom the offender has a child in common. As I understand it, you're not arguing they have a child in common, although I guess in theory, one could try to say that the biological mother has the child as a matter of biological and residual parental rights, and the legal custodian grandmother has the child by virtue of legal custody, so they have a child in common. They just had it in different ways. But you're not trying to argue that, is that correct? You haven't spun out that theory?
We have not put that forward, Your Honor. Of course, the court has an independent obligation to find its jurisdiction, which can't be, waived or created by the parties. So we're the court to believe that.
Fair enough, but
created
just to
protection.
be clear on that, I think our cases say the following, which is we have an independent obligation to make sure we don't exercise jurisdiction we don't have. I don't think it says we have an independent obligation to think up all theories of possible jurisdiction that no one has raised and determine whether they would be applicable or not. So I'm not sure our obligation is quite as you're suggesting, but.
Although here, the trial court, while focused on the custody point, did make a general statement saying the parties are related to each other, are not related to each other whatsoever, quote unquote. And also, this is a legal issue which does not require further development of factual record and, could fall discretionally within the court's power to.
Can I ask you, you've disavowed needing to sort of mix and match forms of relation. Do you concede that you can't do it, or is your point only that you don't do it, or you don't need to do it? Because one could say another way of looking at it would be this idea that the paternal grandmother is, they're related in that one of them is related by blood to the child, and the other has custody, and both forms of relationship are ways you can become connected, and or isn't always exclusive, and so you could be related by A and B, even though it says or. So I know you have said you don't need to connect, mix and match flavors of relation, but do you think you can't, or do you think you could but don't need to?
I think you could but don't need to. I think it's not necessary here. But I absolutely think that is consistent with the legislative history, which.
What about the language of the statute and the or? Do you think that the or is meaningless?
I think they could be related by blood or by custody. And here we found blood and we found custody in the relationships. So we found one of those.
You don't think
in
the or
each
signals,
relationship.
you need to do it one way?
I don't think it signals you must do it solely one way. It doesn't say solely by a category. It doesn't say directly by that category. So I don't, Your Honor.
Yeah, I mean, or in statutes like this can be confusing because it would, if they wrote and in that list, it would seem like you had to have you check every single one of the boxes. So it's a little hard to communicate whether unless you're really specific without using an and or term. To be clear about whether you're permitting sort of multiple connections or mixing and matching, or whether you're not. But so do you think the legislative history says anything suggesting that it is okay to sort of mix and match types of relation, or do you think it's really silent on that other than thematically? I know you think thematically that it is intended to be expansive, and so that's helpful to you on that point, but is there anything that's more specific about the idea that you really can combine forms of relation?
I'm not aware of something in the legislative history that expressly says A plus B. However, as Your Honor's question notes, the legislative history is very clear that the intent was to broaden the act and to incorporate the district's families and to incorporate substance over form. And I think in this situation, on the facts before the court here, we clearly have substance of a family. It may not be a nuclear family of the form of most traditional families, but it is critically substantively a family. And that very relationship, the custodial relationship that exists and the legal custody that exists among the parties is something that has prompted the violence here. Ms. Whitehead repeatedly harassed and threatened to kill Ms. Allen, claiming she had taken the children, She testified in the custody hearing itself that she had gone to her house and threatened her, that she hoped she died, and that she did hope her dead. That those things are all very much connected to this family relationship and the interaction of the parties as a family.
Can I ask you, you argue that the council has kind of expanded the CPO statute over time and that we can draw certain conclusions from that. But is it true that it's only expanded it? And I think, am I correct that had an amendment a few years ago that removed the option for petitioners to get a CPO against, I guess it's your partner's other partner or your ex's partner or your partner's ex, which seems like a pretty clear decision to take a slice out of the breadth of the statute. How does that affect your argument?
I think it actually helps our argument, Your Honor, because it demonstrates that there was a specific category that the council decided to take out, but it otherwise underscores the breadth of the family member definition and the council's intent to encompass family relationships.
To your
And-
point of sort of these family writ large relationships breed these tensions and possibly necessitate the need for this tool, it would seem that the class of people that Judge Beckwith just listed who were removed from the statute would comfortably fall within that group.
Well, I don't know that they fall within the family group. That is that relationship does not necessarily depict a family relationship, unlike the shared custodial parental rights relationship that exists here.
Can I ask you a question about the tense of the statute? So it says to whom the offender is related. And so I'm wondering, another way of looking at this case would be that the biological mother used to have full custody, as parents do, and then she doesn't anymore. So they're related by the fact that one used to have custody and the other now does. And I'm just curious whether you think that doesn't work because the present tense means that the relationship has to exist now, rather than you could say they are right now related by the fact that one used to have custody and the other does not.
Your Honor, I haven't studied that exact question, to be honest, and I dare say I don't necessarily want to take a position on it at this moment. But I think in this case, the current relationship is one of family in substance. And that is absolutely consistent with the legislative history. It's one of blood relations in substance. And again, it's consistent with the protective remedial reading of a statute. And it's consistent with the proper reading, in my view, of the words related by, which is a broad interpretation of those words to effectuate the purposes of the statute. And if we narrowed those words, I think we would, in fact, undercut protections for many people who rely on the Interfamily Offenses Act for an avenue of relief for interfamily violence. I see my time is up. Unless the court has other questions.
Thank you.
Thank you.
Still good morning.
Yes, good morning.
To check.
Yes. Good morning. May it please the court. Pamela Sanchini for the District of Columbia as amicus curiae in support of appellant. The Interfamily Offenses Act, as we've said several times this morning, is a remedial statute that the council has repeatedly instructed the courts to read liberally to protect victims of family abuse. The district appears because the Office of the Attorney General routinely enforces this act on behalf of residents who cannot protect themselves, and the Superior Court's ruling, if affirmed, would leave an entire class of vulnerable people without the civil remedy that that the council has built and repeatedly expanded over the past 50 years. The question is whether a grandmother who holds legal custody of 2 children and the children's biological mother are related by legal custody. And the answer is yes, because of the plain language of the statute, the legislative history, and the remedial purpose. Again, Superior Court erred in reading limitations into the act that are simply not there. We spoke a lot about the plain meaning of legal custody, and I'll do my best to explain why I also don't think it requires stacking of the two. As counsel stated, the two adults in this situation, the mother and the grandmother, relate to each other, are connected to each other only by virtue of the legal custody order. The legal custody order grants the grandmother sole legal custody, the authority to make education decisions, the authority to make certain medical decisions, but at the same time, it requires her to have shared parenting in a sense because she's required to facilitate visitation. So they have to coordinate schedules and timing and handoffs to ensure the best for the children at issue.
This may be equivocal, but I would think it's a pretty substantial overstatement to say that visitation is equivalent to shared parenting. I mean, for sure it requires coordination and like, but I would think that they're pretty different ideas.
I wouldn't say so. I think a parent who has visitation with their children has to, ensure meals, ensure homework, maybe coordinate their visits around medical appointments, administer medication if the children are sick when they come to them.
That's a question. I don't know about this case. I should, but I don't. Is it what's the nature of the visitation that is contemplated by the order at issue? Is it supervised, unsupervised? What do you know the terms of the visitation?
My understanding is that it was unsupervised visitation. So it does require a lot of parenting to happen during the time of visitation,
you
during those
agree that
moments.
the rights, such rights as Ms. Whitehead retains by her status as a biological mother generally, and by way of the custody orders conferral upon her of rights to visitation, are not themselves in fact custody. They're not legal custody. You wouldn't call them meeting the definition of custody. Those rights.
That's correct. The biological mother's rights are not legal custody. They are residual parental rights.
So you say that A can be related to B by legal custody, even though A has all of it and B has none of it, because the relationship doesn't require they both have it. It requires what?
It requires that the two people are connected, or as one court stated, judicially joined in the shared parenting. So these people.
You would exclude hypotheticals like the teacher or the a psychiatrist or a judge who issued the order or those kinds of folks, because although they are connected in many senses of in the broadest sense of the term through that custody order, what is required is that the person who is said to be connected in a way that makes the CPO statute applicable has, your phrase would be shared parenting, or what would be the phrase that you would fill in about what needs to be other than the broad sense of connection?
I think, in fact, the council said it one way in 1982 when the statute was amended to include related by legal custody. The council said it was expanding the act because the prior definition excluded whole classes of people who needed protection. The legislative reports said it was covering bonds of a genuinely familiar, devoted, or homemaking nature. The point of adding this is to include families that, as counsel stated, aren't traditional nuclear families, but families that are created through this legal custody order.
Yeah, I mean, I just struggle with that. I mean, sure, I don't think anybody would say in this instance that Ms. Allen and Ms. Whitehead are homemaking together. They both have interests in this child, and Ms. Allen has legal and physical custody of the child. But I mean, I'm just thinking about in all the custody disputes that we have where we talk about legal custody, we mean one thing, and visitation is another thing, but is not encompassed by legal custody. And if the council wanted familial relationships to include visitation relationships, I would think that they would put that in the statute. I mean, we can't interpret the statute to mean something that the council didn't say.
What the council
and when it used terms of art that are very well known, and legal custody has a clear, definite meaning that I don't think that we would want to muddy in this instance by saying it refers to something broader.
I don't think it expands the meaning of legal custody to say two adults are related to each other because one adult has custody of the other adult's children. The thread that connects these two people is the legal custody of the children. Without that, they are
But
unrelated.
it's not, that's not the only thread then, I guess, right? It's the fact, you know, if you have legal custody of my child, it's the other important thread is that it's my child by blood, by birth, right? Or by previous adoption, but I don't think that I'm related to you solely by the fact that you have legal custody of my child. Right, and in particular, if my rights have been terminated as to my child, I don't think I have a relationship with you at all by virtue. I don't have a, you know, I definitely don't have a relationship with you by virtue of legal custody, and I no longer have a relationship with my child by virtue of blood. It seems like you're overlooking an element, a connective piece here.
I would agree that if parental rights are
Maybe we
terminated,
can stack, I'm sorry to interrupt you. Maybe we can stack and say, okay, we look at legal custody and we look at the blood relationship. But to say that we're just looking at the connection or the relationship by legal custody seems to overread the statute.
I would agree with Your Honor that if parental rights are terminated, there's no longer a connection. There's no right to visitation. There's no including of that individual, of that former parent in the legal custody order.
Can I ask you a related question, which is what if parental rights have not been terminated, but there is no right of visitation? So at the time of the request for a CPO, the order that is in place says biological parent has no right of visitation. Would you say they are the biological parent and the in this case, the legal custodian, in this case, the parental grandmother, are or are not related by custody if there's zero visitation?
I think they're still related by legal custody, even if there's no visitation. I think a parent
why is that?
retains certain residual parental rights. And even if visitation isn't one that they have retained by court order, there may be others. There may be consent to surgery, for example, that a legal custodian cannot do. A legal custodian.
Say they have none. I mean, say really that the grandmother has sole legal physical custody, no right of visitation, and really there is just sort of the residual in theory that the parental rights have yet to be terminated, but there's nothing else going on.
I mean, if there's nothing else going on in practice,
In
I
practice.
can't imagine how the scenario would come up. But if all parental rights have been terminated through a legal custody order, I think there's a problem with the legal custody order. But that's not the situation we have here. We have two people who.
We could be in a situation where where we're marching towards a termination of parental rights. So there's nothing going on, right? There's the child is solely with the new caregiver. The parent whose rights are going to be imminently terminated, right, has no relationship with the child, that, you know, the best efforts has been ceased, all of that. And one could imagine there might be some strong feelings around that. But I'm trying to understand how that would fit under legal custody.
I think we've sort of taken the concept of legal custody a bit farther than it actually expands. Generally
I
speaking,
just thought legal custody was a term of art in the family space, and it seems like your argument and the argument of your colleague requires us to understand legal custody in a much broader way than we typically do.
I don't know that I would agree that it's much broader, but even if it is much broader, the point of this statute is to cover these precise situations where we have two people with interest in the same children that are connected to each other via this legal custody order, and protection is needed for the children.
Can I ask you to respond to a couple questions I asked your colleague, one of which was about the tense of the statute. I mean, another way of looking at the connection between these two folks is that one used to have full legal custody and the other now does. But the tense of the statute seems like it's at least possibly a problem with that. Do you have a view about whether they could be viewed as related by legal custody in the sense that one succeeded the other as legal custodian?
Do not. I think it is limited by, is related by, and that currently these two individuals have to be connected to each other via a valid current legal custody order.
And then do you, I think you seem to suggest that you thought in a setting where there had been a termination of parental rights, I think what you said literally was they would no longer be related by custody, you thought in that hypothetical. But I'm not sure whether you said you think they would also not be covered at all, which in turn raises the question discussed with your colleague about whether you can, what I was calling mix and matching. Stacking is multiple steps, but might be the same. You could be, related by blood through a person, which would be sort of stacking, but might not be mixing and matching. So I'm thinking of mixing and matching in my terminology as, could you think in a case where there was termination of parental rights that whatever that means in terms of legal status, it's nevertheless the case that there's a blood, they were related by blood. They still are. That doesn't, change the DNA relationship that might be referred to by blood. And that gets you part of the way. And the rest of the way would be the current legal custodian order. So my abstract question is, do you think mixing and matching is permissible under the statute? Or do you think, I know you think it's not necessary here, but do you think it's permissible or do you think it's impermissible?
I don't think it's impermissible. And I think if we're reading the statute broadly to effectuate its purpose, then I think it could be included. I don't think it's necessary here. I think these two folks are very directly, well, maybe directly is not the right word, but very regularly connected via their shared interest in these children.
And do you have a reaction to I raised the question of whether, as the parties have, the parties who appeared have focused on suggesting that related by in the statute should be understood to mean connected in some way, or whether instead it could or should be read to mean are relatives in some way. Do you have a view about which of those ways we should be looking at that phrase and why?
I think it should be the former, connected by. I think you could have situations, and we do have situations where perhaps a family friend has legal custody of the children. They're not family members, but they are connected to each other via the legal custody order.
What if
And-
there isn't a legal custody order? I mean, imagine hypothetically, there's, an interaction between a man and a woman, brief, and woman gets pregnant, and, a year later, the man realizes there's a child. There's no custody order. And he then, wants to have a relationship with this child. Are they family members?
I think they're intimate partners because
There's no current relationship between them. It was a one night stand.
But the intimate partner doesn't require an ongoing relationship. It just requires a child in common. So these two individuals would have a child in common. So I don't think we would need to get to the question of
What if it's the grandmother of the intimate partner?
Then I think no. I think, as the court stated, legal custody has a very precise definition. And I think the two adults that we're speaking about need to have that connection through legal custody of the children, through marriage, adoption, one of the other listed. But I think if your family friend just assumed care of your children informally without a legal custody order, then perhaps the act wouldn't apply. If it's an informal arrangement, I think what connects.
I'm envisioning the mother has custody of their own child, and the grandmother is seeking a relationship with the child. The paternal.
I think the other limiting factor here is that it requires.
I'm just
criminal offense.
asking about, there's no legal custody relationship there.
Right. But I think a grandmother seeking a relationship with her children wouldn't fall under the act here because it still requires a criminal offense, a crime against the person. And a grandmother seeking custody.
Assume that she's not seeking custody.
They're seeking a
there's
visitation, a relationship.
there is a triggering event that
Okay.
makes the mother want to get a CPO against this person. Is this person a family member?
Without stacking, probably not.
Can
If
I ask
there's
you,
no
do you have a
custody.
reaction to the suggestion of your colleague that you might view the two folks here as related by blood? Because that's an undefined and somewhat elastic concept, and you could think of them as through their shared blood relation, related by blood in a extended family kind of way. Do you have a view? I don't think the district took a position on that as brief. So I'm curious if you
No,
have a
and-
view or you want to remain agnostic on the topic.
I think I'd like to remain agnostic on the topic.
Can I ask you, were you about to follow up? Okay, can I ask you, you said a couple of minutes ago that protection is needed for the children. I think if the threat, if there were threat of violence or violence against the children themselves, would Ms. Allen be able to get a CPO Ms. Allen be able to get a CPO on the children's behalf?
If the acts of violence were directed at the children, yes, she would. But in
So-
this particular case, the acts of violence were directed against the adult,
Okay,
not
but
against the
when
children.
you said protection is needed for the children, that's just.
Yes, through their exposure to domestic violence, which is just, has a lot of harmful consequences. As we discussed in the brief, and as the council has pointed out, the children's repeated exposure to violence in the home can affect their sense of stability and cause other sort of long-term consequences. So protecting in that sense, yes, but I don't think that based on these facts that she could have sought a protective order on their behalf. In different situations with different facts, yes, she absolutely could.
You have a reaction just on other things that haven't been briefed. I'm curious about to the question of whether these two folks could be viewed as, it sounds a funny way of saying it, and this might explain why an answer, but could be viewed as fitting under the definition under 6A of intimate partners because they have a child in common in sense of having, meaning biological or having custody of. Do you think that's, do you have a reaction to that, or you feel free to also be agnostic about it because it wasn't brief?
I do think that's one way of reading it. I think that when they moved that definition into intimate partners, it sort of seemed to exclude it. But I do also know that there are other states who have included this precise situation under a definition of children in common. I think it's the state's not coming to me, but I know it's cited in our brief. But they have included children in common to cover the precise situation that we're discussing here. The only thing I would add as far as the district's interests is to reiterate the huge number of children in the district that are living in this situation. I think in our brief, we said 9,000, which was a 2022 statistic, and KinCare Alliance cited 14,000 as a 2024 statistic, which is 11% of the children in the district are living in situations just like this.
How do you define that?
Children living
In
with,
this situation, yeah.
in the legal custody of a non-parent.
Non-parent and non-relative, or
A non-parent. So whether it's a grandparent or kin-like family caretaker.
But you mean non-parent kin, because you don't mean people like in foster care unrelated. You mean
No,
11,000
correct.
people are
I'm not
non-parent
referring to
kin, but
foster
you're talking about
care. If we
non-parent
include
kin.
foster care, that's a whole different number for
Understood.
sure.
Right. So I
Yes.
just want to make sure we're talking about
Yeah.
non-parent family members.
Yeah.
In a normal sense, kin in a relatively narrowly understood
Yeah.
way of grandparents or uncles or other things like siblings.
Correct.
I mean, I take your point, and clearly this is an area of, public interest, and there are strong public policy arguments in favor of covering this relationship. I guess, the question before us is whether the council did in this statute. And, there could be a very good argument to go back to the council and say,
Write it better.
there's a hole, right?
Yes.
Um,
I mean, arguably, I don't believe there's a hole. I understand the court's questions. I think that if
And
we
to have the
don't,
council address some of the concerns that have been discussed today about overreach.
but if related by legal custody does not include these two adults, it's difficult to imagine which two adults other than the co-legal custodians that this would cover. Because a legal custodian can't seek a CPO against the child that they have legal custody of. A young child under 13 can't seek a CPO against their custodian. So it starts to narrow that class of people that are covered by this phrase, when in reality, two adults who have a shared interest, one through legal custody and the other because they're the parent, are connected because of legal custody. So I do think that it precisely covers this situation here. Maybe there are more other situations where it becomes too attenuated, but here we have two adults who have to interact regularly with each other by virtue of the legal custody order. And this is precisely the scenario that the Interfamily Offenses Act was meant to cover. There's no other questions. We would ask the court to reverse and remand. Thank
Thank you,
you.
Ms. Sanchini, and thank you, Ms. Vaughan, for your arguments today. The case will be submitted.